Thank you. Be seated. Okay, good morning, everyone. We will call this hearing to order and ask Mr. Butler to read the docket, please.
Yes, good morning. Thank you. Madam Chair and members of the Commission, this is docket number 2015-54E, which is the petition of South Carolina Electric and Gas Company for approval to participate in a distributed energy resource program. South Carolina Electric and Gas has filed a petition for approval to participate in a distributed energy resource program and for recovery of program costs as a separate component of the company's overall fuel factor. Please take notice that a hearing on this matter has been scheduled to begin on Tuesday, June 2nd, 2015 at 10:30 a.m. before the Commission in the Commission's hearing room at 101 Executive Center Drive, Saluda Building, Columbia, South Carolina, for the purpose of receiving testimony and evidence from all interested parties. Madam Chair and other members of the Commission, the docket is in order.
Okay, thank you, sir. Also, let me remind everyone, for the second time, we are live streaming, and we thank our ETV cameraman for being here this morning. We will do appearances now. Who appears for South Carolina Electric and Gas?
Good morning, Madam Chairman, members of the Commission. My name is Chad Burgess, and with me is Matthew Gissendaner. He and I are in-house corporate counsel for SC&G, and we also have with us today Belton Ziegler of the law firm Womble Carlisle. It's our pleasure to appear before you today, and we appreciate the opportunity to present the company's case. Thank you.
All right, thank you, sir. And who appears for Walmart Stores?
Good morning, Madam Chairman.
Good morning.
I'm Shannon Hudson with the Office of Regulatory Staff. Stephanie Roberts will be here on behalf of Walmart. She experienced car trouble this morning, and we emailed back and forth. The car is now okay. She's stuck on I-77, though, for a wreck. Her latest email said that she hopes to be here around 11 o'clock.
Okay, all right.
Thank you.
Maybe she should call an Uber. Who appears for South Carolina Energy Users Committee?
Madam Chair, I'm Scott Elliott. I'm here on behalf of the Energy.
Okay. And for the Alliance for Solar Choice?
Good morning, Madam Chair. Thad Cully, law firm Key Spots and Weaver, on behalf of the Alliance for Solar Choice. And Joe McCollum.
Good morning. All right, and South Carolina Solar Business Alliance?
Madam Chairwoman Bonnie Loomis, I'm here from the South Carolina Solar Business Alliance. I'm happy to report that I wanted to say what you were back here today.
Okay, thank you.
For your indulgence last week.
Of course, not a problem. Okay, and for the Sierra Club?
Madam Chair, Commissioners, good morning. Robert Dial for the Sierra Club.
Okay. And for the South Carolina Coastal Conservation League and the South Carolina Alliance for Clean Energy?
Madam Chair, members of the Commission, Bland Hallman with the Southern Environmental Law Center representing CCL and SACE. Glad to be back with you this week.
Okay, thank you. And who represents the electric cooperatives of South Carolina and the Central Electric Power Cooperative?
Madam Chairman, Charlie Terrain.
Okay. All right, awesome. And who else is here for ORS, Ms. Hudson?
Good morning again. Andrew Bateman is here with me on behalf of the Office of Regulatory Staff.
Okay. All right. Thank you, everyone. Now, does anyone wish to give an opening statement? Mr. Gile?
Madam Chair, just briefly, I would like to state Sierra Club's position. Good morning, Commissioners. I want to compliment the parties, and particularly the Office of Regulatory Staff, for their hard work in negotiating and discussing the elements of this important settlement that's proposed. State that Sierra Club, while it elects not to be a formal party to the agreement, has no objections to its adoption and urges the Commission to adopt the settlement agreement as an important step to advancing distributed energy resource supply and sale.
And I'm sorry, I forgot to ask, is there anything that we need to put into the record before we begin?
Madam Chairman, if I may, we have a settlement agreement in this case. It was filed on May the 26th. It is signed by all parties except three. The three non-signing parties are the Electric Cooperatives of South Carolina, Central Electric Cooperative, and the Sierra Club. They have kindly given me permission to state that they do not object to the settlement agreement. The end result is what you have before you is an uncontested case. The settlement agreement covers SC&G's petition for a distributed energy resource program pursuant to Act 236. Specifically, the settlement agreement covers incentives for South Carolina renewable energy facilities, cost recovery, renewable energy credits, program modification, and the development of an advisory group. The settlement agreement is the result of a lot of hard work, flexibility, and collaboration among all the parties, and I thank you all. Thank you all very much. The parties have agreed to waive cross-examination, and Madam Chairman, if there is no objection, we ask that the settlement agreement be marked for identification and entered into the record as the first hearing exhibit.
Okay, settlement agreement will be hearing exhibit number 1.
Thank you, Madam Chairman.
Okay, thank you. And if no other parties wish to give a opening statement, or is there anyone from the public that would wish to address the commission?
Madam Chair, as I understand it, we do have one public witness this morning. His name's Mr. Victor Vietzkin, and we'll ask Mr. Vietzkin to come forward. And please, if you will, sir, have a seat and talk into that mic in front of you. And if you will, before you start, go ahead and give us your full name and address for the court reporter, and then you can go ahead and proceed with your statement.
Good morning, ladies and gentlemen. My name is Victor Vietzkin, and I'm not representing anyone except myself as a resident of this area. I want
Mr. Vietzkin, if you can just raise your hand to be sworn, please, before you begin your statement. Raise your right hand, please, sir.
Yes, I want to say just a couple of words. I presented my comments, and I'm raising both of my hands for using renewable energy, solar energy in particular, as South Carolina Electric and Gas wants to use this part of the energy. I guess using renewable energy will give certain benefits to all of us, to South Carolina Electric and Gas, to other companies, and to the residents. But there is some things we need to remember. While energy, renewable energy, is considered as a cheap energy, it is energy from nature, it is energy from sun. It will require a lot of money at the beginning to install the panels, to manufacture the panels, and so on. And that's why South Carolina Electric and Gas ask millions of dollars for this. Nevertheless, later, when the panels installed, when everything is done and the energy is produced, this energy must be cheaper than energy produced by regular electric plants like coal plants or gas or whatever. And that's why I consider that electricity rates should be lowered. I want to mention that to install these panels, solar panels, I don't need South Carolina Electric and Gas. I can buy these solar panels and install it myself and save the energy. But the installation is pretty expensive. That's why South Carolina Electric and Gas called for this money. And I understand this, and as I am saying, I will pay for this. But later, when South Carolina Electric and Gas start using this energy, the rates of electricity should be reduced for some levels, because electricity will be consumed by the electric plants and this solar panel field. I could not find anywhere in that petition any mentioning of reducing electricity rates. And that is what I think residential, at least residential customers, are looking for. That is why I consider that before South Carolina Electric and Gas give us some numbers of reducing rates, not increasing rates, these hearings should be either postponed or canceled until South Carolina Electric and Gas Company is clear with this. That is what I wanted to say. And everything else in my comments, which I presented already here. Thank you.
All right, thank you, Mr. Vieskin. Mr. Vieskin, if you can just sit back down, sir. Mr. Vieskin, sir, if you could just sit back down, please, in case any parties or commissioners have any questions for you. Parties, any questions for Mr. Vieskin?
No questions from SC.
All right. Okay. All right, and we will enter Mr. Vieskin's statement and make it hearing exhibit number 2. Commissioners, any questions? Okay, all right. Thank you so much for your comments, Mr. Vieskin. You may be excused, sir. All right. Mr. Burgess, you may call your first panel.
SC&G
you're
calls
ready.
John Raftery and Alan Rooks to the stand.
Okay. And while your panel is getting ready, I'll just let everyone know what the schedule will be for today. We will break for lunch approximately 12:30. We will try to break every hour and a half or so, and we'll go as long as we need to finish today.
You would raise your right hands, gentlemen. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Mr. Raftery, will you please state your name for the record?
John Howard Raftery.
And by whom are you employed and in what capacity?
By South Carolina Electric and Gas, I'm the General Manager of Renewable Products and Services in Energy Demand Management.
And have you prepared or caused to be prepared and pre-filed in this docket 24 pages of direct testimony?
I have, yes?
And are there any changes or corrections to your direct testimony?
No.
And if I ask you all the questions contained in your direct testimony, would your answer
Mr.
be the
Burgess,
same?
is your mic on? I can hardly hear you.
I believe it's on, yes.
Okay. Maybe bring it closer. I don't know.
Are there any changes or corrections required of your testimony?
No.
Madam Chairman, at this time, we would move into the evidence of record, the pre-filed direct testimony of John Raftery as if given orally from the stand.
All right, Mr. Raftery's testimony will be given, entered into the record as if given orally from the stand.
And do you have an exhibit also attached to your pre-filed direct testimony?
Yes?
Are there any changes or corrections required of that?
No.
Madam Chairman, we would move into the evidence, the exhibit, which is identified as JHR1, that was attached to Mr. Raftery's pre-filed direct testimony and asked to be marked as the next hearing exhibit.
Okay, Mr. Raftery's exhibit will be entered into the record as hearing exhibit number 3.
And Mr. Raftery, have you also pre-filed in this docket supplemental direct testimony consisting of 3 pages?
Yes, I have.
And are there any changes or corrections required of your supplemental direct testimony?
No, there are not.
Madam Chairman, we would move into the record of evidence the supplemental direct testimony of John Raftery as if given orally from the stand.
All right, supplemental direct testimony will be entered into the record as if given orally from the stand.
And lastly, Mr. Raftery, have you also caused to be prepared and pre-filed in this docket rebuttal testimony consisting of 3 pages?
I did, yes?
Any changes or corrections required of your rebuttal testimony?
No.
Madam Chairman, we would move into the evidence of record the pre-filed rebuttal testimony of John Raftery as if given orally from the stand.
All right, pre-filed rebuttal, entered as if given orally.
Mr. Raftery, have you prepared a summary of your direct testimony?
Yes, I have.
Would you please deliver that this time?
Madam Chairman and members of the Commission, SC&G comes before you today asking for approval of its initial Distributed Energy Resource Program. To be approved, DER programs must encourage the installation of customer scale and utility scale DER resources. For each category, the goal is to encourage the installation of capacity equaling 1% of the utility's 5-year average retail peak demand. The target date is January 1st, 2021. The plan proposed in the petition envisioned installation of 48.3 megawatts of utility scale capacity and 46.6 megawatts of customer scale capacity by the target date. Utility scale capacity is capacity that is between 1 and 10 megawatts per installation. Customer scale is less than 1 megawatt. For both categories of capacity, the plan would meet the 1% statutory target, which for SCE&G is 42 megawatts. ORS witness Linda Schaefer is presenting the details of a settlement agreement in this docket, which modifies the plan. Under it, the forecast for utility scale capacity does not change. Customer scale DER will increase by approximately 1/2 megawatt to 47.2 megawatts. DER programs must also encourage residential small commercial installations of less than 20 kW. The goal is 25% of the 42 megawatt customer scale target, or 10.5 megawatts. The programs presented in the petition would encourage installation of 17.8 megawatts of residential small commercial capacity. Under the settlement agreement, the forecasted capacity will drop by approximately 1 megawatt to 16.8 megawatts, due primarily to the agreement to reserve the community solar capacity from accounting in the segment at this time. But this program still easily meets the statutory target. SCE&G is currently undertaking construction of utility-scale solar farms at Otari on I-77 in Casey and Leeds Avenue in North Charleston. They represent a combined capacity of 4.3 megawatts. Energy produced by such resources will be sold by the developers to the company under 20-year power purchase agreements at a specified rate per kWh. That rate is established by an RFP process. SCE&G's plan calls for more than 32.2 megawatts of utility scale capacity to be installed by the end of 2016. That means approximately 67% of the plan's total utility scale megawatts should be in place before the reductions in federal investment tax credits take place. In the settlement in the recent net energy metering docket, SCE&G agreed to incentivize NEM rates 1-for-1 by making the credit attributed to the customer's generation equal to the rate charged for the customer's consumption. The NEM settlement provided that the difference between the value of the customer's generation to the system and this 1-for-1 rate would be treated as a DER program cost. Accordingly, the cost of the 1-for-1 NEM incentive is included as a DER program cost here. In the settlement agreement in this docket, SCE&G agreed to add an additional performance-based incentive to the 1-for-1 net energy metering incentive. This incentive will begin at 4 cents per kilowatt hour generated and will decline to 0 in 1 cent decrements as capacity targets are reached. The additional incentives will apply to residential NEM installations that are less than 20 kW. Under this program, each customer's incentive rate will be established at the time of the approved application for the program. It will then be fixed for 10 years. SCE&G is also proposing to make 10-year bill credit agreements available to non-residential DER customers. Under these agreements, SCE&G will provide customers bill credits which will vary from 22 cents to 14 cents per kWh generated depending on the size of the installation and whether the customer was tax exempt or not. Under the settlement agreement, bill credit agreements will not be available to residential customers. Instead, they will receive the 1-for-1 net energy metering credit and the additional performance-based incentive. SCE&G will also offer residential customers a community solar program. Under it, an individual can purchase up to 20 kilowatts of solar panels in a community solar farm. These panels will be maintained by the solar farm developer. SCE&G will credit each customer's electric bill with a percentage of the total output of the solar farm. That percentage will equal the percentage of the solar farm's total capacity that is owned by that customer. That incentive will be 10 cents per kWh delivered. The term of the contract with the customer will be 20 years. A customer who moves within SCE&G's system can transfer the credit to its new location. A customer can also transfer its panels to another eligible SCE&G customer and assign the credit agreement to the new owner. Community Solar provides customers the opportunity to participate in a DER program if they are renters, have a shaded lot and do not want to cut down their trees, or do not have a suitable roof or other location for solar installations. Community Solar makes solar DER available to customers at much lower cost per kW than individual rooftop installations with no maintenance issues. It can also be a vehicle for providing DER opportunities to credit challenge customers and tax-exempt customers. SCE&G has reviewed the incentive levels for these programs and believes that they are reasonable. We have developed a plan for communicating these programs to our customers in conjunction with solar developers. We will monitor market responses to these programs and make adjustments as necessary. We will consider adding additional programs as opportunities arise. SCE&G will have the right at any time to respectfully request of the Commission to authorize modifications or amendments to its DER program. Under the settlement agreement, such requests would require Commission approval if payments or adjustments to the incentives by 25% or more. SCE&G proposes to make participation in its DER program available to customers who installed qualifying DER facilities after January 1st of this year, 2015. This is consistent with the terms of the settlement agreement in the net energy metering docket and DER dockets. Other provisions of SCE&G's DER plans are discussed in my pre-filed testimony and the settlement testimony of Ms. Schaefer. SCE&G's original proposals are subject to any amendments contained in the settlement agreement. This concludes my summary.
Have you also prepared a summary of your supplemental direct testimony?
Yes.
Would you please deliver that at this time?
Madam Chairman and Commissioners, my supplemental testimony explains that in today's market, customers could expect to pay approximately $200 to purchase a 100-watt solar panel in a community solar farm. This is about half the cost of rooftop installation. I also discuss how interest rates would have been set under the proposed leasing program and how the length of the recovery period for investments would have been determined under that program. These later points are no longer relevant in light of the settlement agreement. This concludes my summary.
And have you also prepared a summary of your rebuttal testimony?
Yes.
Would you please deliver that?
Madam Chairman and Commissioners, in my rebuttal testimony, I discussed certain points raised in the testimony filed by other parties. Specifically, SCE&G agrees that a net energy metering incentive program and bill credit agreement program are not intended to discriminate against lessors to DER facilities. The company also agrees that solar facilities may be sized to reflect the customer's energy consumption and not demand. As a matter of fairness to other customers, SCE&G disagrees with the position that DER incentives should not be limited or should never expire. My rebuttal testimony was filed before the settlement agreement was concluded. In light of the settlement agreement, the other matters discussed in my pre-filed rebuttal testimony are of limited importance to the issues to be decided here. This concludes my summary.
Thank you, Mr. Raftery. Mr. Rooks, would you please state your full name for the record?
Alan Wessinger Rooks.
And by whom are you employed and in what capacity?
By SCANA Services as Manager of Electric Pricing and Rate Administration.
And have you prepared or caused to be prepared under your direct supervision direct testimony consisting of 9 pages?
I have.
And are there any changes or corrections required to your testimony?
There are none.
And if I ask you all the questions contained in your direct testimony, would your answers be the same?
They would.
Madam Chairman, we would move into the record of evidence, the pre-filed direct testimony of Alan Rooks as if given orally from the stand.
All right, Mr. Rook's testimony will be entered into the record as if given orally.
Mr. Rooks, have you also prepared and pre-filed in this docket supplemental direct testimony?
I have.
Do you have any changes or corrections to that supplemental testimony?
I have 2 small edits. Okay.
Would you please direct the commission and the parties to the page number and the line number where the corrections are required?
On page 1 of my supplemental testimony, on line 13, that should read docket on. So testimony in this docket on April 16, 2015. Also, on the final page of the supplemental testimony, page 4, line 19, between environmental and avoided, strike the word and. And those are the changes that I have.
And with those changes, Mr. Rooks, if I ask you all the questions contained in your supplemental direct testimony, would your answers be the same?
They would.
Madam Chairman, subject to the corrections noted by Mr. Rooks, we would move into the record the pre-filed supplemental direct testimony of Alan Rooks as if given orally from the stand.
All right, Mr. Rooks' supplemental testimony will be entered to the record as if given orally.
Mr. Rooks, did you have any exhibits attached to your supplemental direct testimony?
I did.
Are there any changes or corrections required of those exhibits?
There are none.
Madam Chairman, we would move into the evidence of record the pre-filed exhibits attached to Mr. Rooks' supplemental direct testimony. Those are identified as AWR 1, 2, and 3 and asked that it be marked as the next hearing exhibit.
All right, Mr. Rooks' exhibits AWR 1 through 3 will be entered into the record as hearing exhibit number 4.
Thank you, Madam Chairman. Mr. Rooks, have you prepared a summary of your direct testimony?
I have.
Would you please deliver that at this time?
Sure. Good morning, Madam Chairman and members of the Commission. The South Carolina Distributed Energy Resource Act permits an electrical utility to recover the incremental costs and avoided costs that it incurs in implementing Commission-approved DER programs. Avoided costs are costs that the company avoids by receiving power from another entity rather than generating the power itself. The DER Act specifies that avoided costs are established under the Public Utility Regulatory Policies Act, or PURPA. PURPA avoided costs are based on well-understood regulatory principles and are easily calculated. Incremental costs are the other costs that the company incurs in implementing a DER program. Incremental costs include incentive costs. These are the costs of the credits and payments to customers or solar developers to support their provisions of DER to the system. For cost recovery purposes, incentive costs are net of any avoided costs that are included in these payments. Program costs are the other element of incremental costs. They include the company's expenses associated with administering DER programs, investing in DER resources, investing in equipment and facilities necessary to integrate DER into its system, and related costs to the company. Section 5827-865A states that incremental and avoided costs of DER programs shall be allocated and recovered based on the same method that is used by the utility to allocate and recover variable environmental costs. The company's plan allocates incremental costs among 3 customer classes: residential, small and medium general service, and large general service. Allocations will be based upon the respective pro rata share of SCE&G's firm peak demand represented by these classes for each year. Allocated costs will then be divided by the total number of customer accounts for each class. The result will be a fixed monthly charge for each customer class to be added to the customer's bill. The Act requires that we ensure that incremental costs related to the DER program do not exceed a specific annual amount per customer account. That amount is $12 for residential customers, $120 per commercial account, and $1,200 per industrial account. For purposes of these caps, the company considers its small and medium general service customer classes to be commercial accounts and its large general service customer class to be industrial accounts. The company believes that a per-account charge is the most logical and transparent means to ensure that these caps are not exceeded. Anything other than a per-account charge could result in some customers paying more than the capped amount and some customers paying less. South Carolina Code, Section 5827-865, does not require a particular billing method for incremental cost recovery. It requires only that the allocation among customer classes be based on demand as is being proposed here. Because there are relatively few members of the industrial class, this class will reach its per-account cap quickly. If SCE&G were simply to cap DER spending when the per-account charge on this class reached the maximum, and the total allowable DER program cost would be less than $2 million annually. This is far less than what must be spent to reach the statutory goals. To resolve this conflict, SCE&G proposes capping annual recovery by customer class and carrying forward unrecovered costs for collection among all classes in the following year. In this way, SCE&G can offer DER programs that meet the statutory goals while still assuring that no customer pays more than its statutory cap.
Excuse
Using
me,
this-
Mr. Rooks, I'm sorry to interrupt you. The people in the back can't hear you, so if you can pull your microphone closer and speak directly into it, let's see if they can hear you better.
Test.
Yeah, that's better? Okay. All right, now, thank you.
Okay. Test.
I think it was better before.
How's this?
Yeah, that's good.
Okay.
That's good.
Using this approach ensures that the future recovery of the balances carried forward does not become impractical. Avoided costs will be incorporated into customers' per kilowatt-hour rates and therefore will not be separately stated on bills. The incremental cost for each customer class will be separately stated as a dollar amount charged to each account, similarly to how basic facilities charges are currently billed. This concludes the summary of my direct testimony.
Mr. Rooks, have you also summarized, or prepared a summary rather, of your supplemental direct testimony?
I have.
Would you please deliver that at this time?
Sure. My supplemental testimony provides a numerical example that shows how the company expects to comply with statutory cost allocations and caps associated with incremental DER costs. The example is based on current incremental cost forecasts. It shows that during the first program year of the DER plan, the incremental charges to the residential and small and medium general service classes would be below the cap specified in section 5839-150, while the large general service class would reach its $1,200 annual cap per account. SCE&G plans to carry forward the costs that exceed the cap with carrying costs for collection among all classes in the following year. My supplemental testimony also attaches a tariff sheet that sets forth the language for recovery of avoided and incremental costs in the next fuel clause proceeding. This concludes the summary of my supplemental testimony.
Thank you, Mr. Rooks. Madam Chairman, Mr. Raftery and Mr. Rooks are available for examination by the non-settling parties as well as questioning from the commissioners. Thank you.
Right, any cross-examining from any non-settling parties?
No questions, ma'am.
Okay. All right, commissioners. Commissioner Howard.
Thank you. Mr. Rafferty, I have a couple of questions for you. Did SC&G consider incorporating any upfront subsidies, such as rebates, to encourage customers to participate in the DER program?
Commissioner Howard, we did consider upfront rebates. We feel that a production-based incentive is a more true way of bringing renewable resources to the system. It really incents the energy that is added to the grid. Upfront rebates or upfront incentives certainly have, in certain jurisdictions, proved to be successful, but we think through our collaboration with the installers of South Carolina, the national organizations, a net energy metering plus a production-based incentive will get us there and really bring the renewable energy to the system that I think was a core part of the spirit of Act 236. But to answer your question, we did consider it, but we feel a production-based incentive is better for us given our rate structures right now.
Okay, thank you.
Yes, you're welcome.
Well, how did you determine the proposed bill credit adjustment rates and the performance-based incentive rates? How did you determine those rates?
We performed internal modeling. So our goal has always been price certainty and a payback period. So we want these systems, or we feel the market requires that these systems will be paid back in a defined term, and we started at about 10 years. And so we ran our models, and then we began to talk to people. We talked to the installers that I mentioned and some of the national organizations, and compared models and collaborated. We came to about the same point, same production-based incentive rates. But we didn't stop there. We enlisted the help of a national organization, a company out of California called Clean Power Research, and they do rate design. So we had them model the different scenarios that are put forward, the bill credit agreements, and we determined that where we are entering the market should provide the adoptions to get us to the statutory goals set out in Act 236. So a number of different individuals and outside organizations helped us build those production-based incentives and bill credit agreement rates.
Thank you.
Okay.
Under what circumstances would LC&G seek commission approval of modification or changes in any of the DER programs? And does that program allow us to suspend approval while it's being reviewed by the commission?
As part of the settlement agreement, we clarified our position on that. Specifically, any additions or terminations of programs, we would respectfully submit to the commission for approval, as well as any modifications to the incentives of more than 25%. If there's an adjustment to one of the incentives that's less than 25%, we would notice the commission of the change. But additionally, in that settlement agreement, we discussed notification of a distributed energy resource advisory group. So 15 days ahead of any of those filings or notices, we would inform that group. So
on page, I think it's, let me get it for you. Anyway, you had a statement that you would have a chance to review the program, and if it wasn't getting enough participation, or if it was getting too much participation, that you could suspend it or adjust it. How long would that time period be before you make that decision of whether the program is reaching who it's supposed to reach, or is, for the lack of a better word, overreaching?
No defined period. I think we said no less than annually. I can tell you that John Raftery will be looking at it every day. I'll be looking at adoptions every day, every week, every month, every quarter. The DERP advisory group, we will convene no less than 2 times per year. So I can't see it being less than a 6-month period, but annually, I certainly would see us looking at the programs and as a company proposing modifications, additions, or terminations of programs.
Thank you very much. Thank you, Madam Chairman.
Thank you, Commissioner Howard. Commissioner Hamilton.
Thank you, Madam Chair. Happy to have both of you gentlemen with us today. Mr. Rooks, I'm reading from your testimony on page 8 of page 8, line on page 8, lines 18 through 22 of your direct testimony.
Yes,
You state that if SC&G were simply to cap distributed energy resources spending when the per account charge of the first customer class reached its maximum amount, then it would be impossible to generate sufficient funds to reach the minimum statutory goal for distributed energy resource programs, which is 2% of 5-year average retail demand by December 31st, 2020. You go on to state that SCE&G's total allowable distributed energy resource program cost budget would be limited to less than $2 million annually. Would you please explain to us how the number was calculated?
The $2 million?
Yes, sir.
If you would, could you please turn over to my supplemental testimony?
All right.
My exhibit AWR, supplemental exhibit AWR 1.
All right, sir. Okay.
We ready?
Yes, sir.
Okay. On that exhibit, if we were to go down and take a look at the estimated annual collection amounts for the industrial class, if I could call your attention to that, it should be line 14.
Yes, sir.
And you see a value there of $387,600?
I do.
Okay. That is the amount of revenue recovery that we would recognize charging the statutory cap for all of our large general service class customers, if you will. If you were to take that number then, and we're kind of going backwards with our math here, and divide it by the industrial cost allocation that you see on line 5, the 23.58%, you would arrive at a value of somewhere between 1.6 and 1.7 million dollars. So if we were to stop cost recovery at a point where the first customer class reached its statutory cap, then that budget could not exceed any more than about 1.6 or 1.7 million. And that's where the calculation originates, and the less than 2 million that you see in my direct testimony.
Okay, so what are you saying the maximum allowable spending amounts under the statutory cash cap is what now, the total? The allowable?
I think the allowable amount we view as, certainly the statute mandates that we allocate based off prior year peak demand. So we view that as the first test. And then we would allocate those costs. After that allocation, we would divide through by the number of accounts for each class to arrive at a charge. And what we've said is that we will not exceed the cap for any class of customers in applying the DER charges. Now, if there are any amounts that would be left over, as in if we apply the statutory cost cap and there's an unrecovered balance left over, we would carry that forward to the next year and allocate it among the customer classes to be recovered during that particular DER proceeding, if you will, when we file and have our annual fuel proceedings for recovery. So we believe that this is a fair and reasonable way to balance applying the law as well as achieving the goals that the legislature had set forth for us for these solar targets. The alternatives would be, if we did not apply it in this manner, to shut down some programs perhaps, or to build up a large under-recovered balance that would carry from year to year and get larger and larger. And we didn't feel either one of those scenarios was a workable solution here.
Thank you very much, Mr. Brooks. Mr. Rafter, if fully subscribed, do you have the estimate of the impact of distributed energy resource programs on SCG's cost of generation?
On the cost of generation?
Right.
Let me attempt to answer that, and you guide me if I don't do it well enough. Our distributed energy resource programs will add about 5,000 customers. So about 5,000 customers in total will have DER facilities on the rooftop, or they will be participating in a community solar farm. The total megawatts I read earlier in my testimony. The additions from a customer scale will be 47.2 megawatts, and then the utility scale will stay at 46.6. As we go through these programs and provide these production-based incentives, there will be additional costs. It's about $37.7 million over the 5-year period. But after we get out of paying the incentives, we will pay at avoided cost. So we will be paying, it'll be a least cost resource, generation resource. So there wouldn't be any additional expenses after the customers migrate out of these plans. So I'm not sure if I answered your question about the impact of generation costs, but it might be a combination.
Well, it's going to be more or less, or?
It'll be more for the short period while these incentives exist, but after we get out of the incentive period, those 10-year contracts, they will be paid at avoided cost.
Okay, thank you, sir.
You're welcome.
All right, one other question I have for you. Do you have an estimate of the cost to maintain a solar panel on a residential residence?
Yeah, I remember a question coming up in the other hearing about it creating a whole nother business, and I thought about maybe I should get in that business, but I don't want to climb up on a roof.
I think it's lucrative.
Yeah, well, so you can model it, and typically the models will say about, and I'm talking about residential or commercial or small commercial, you could model it at about $15 per kilowatt of AC. So it's And I'm talking an annual amount, and I think that's actually a little high. So a residential customer should consider about annually spending about $75 per year in having someone, wash it, scrub it, blow off the grime or the tar.
All right, then, if you, with your good memory from the previous hearing, is the maintenance cost per panel installed different on a commercial or utility scale?
It absolutely is. I couldn't quote you numbers, but it's just a matter of economies of scale. If you have a large ground mount utility scale solar farm, it would be easier to maintain and clean and ensure the production, which is a nice feature of utility scale farms or community solar farms. That cost increases per kilowatt as you transition into commercial or industrial, and certainly is the highest when you're going to an individual resident's home on their rooftop and cleaning it that way. So it scales. So the number I gave you, about $15 per kilowatt, would be the high end, and then it would gradually come down.
During your study in bringing this program forward, did you conceive any ideas as to the popularity of rooftop versus solar farm?
The spirit of the act talked about a diversified portfolio.
Yeah.
So and it certainly split it up between customer scale and utility scale. So I mean those are two diverse areas. We kind of introduced another one in between, which was community solar, and that really serves the 60 to 75% of the population that doesn't want to do it on the rooftop or can't because of bad roof orientation, improper roof structure, shading, renters, multifamily housing. So I think we've taken into consideration a broad suite of programs to serve those different interests, and we're real excited to get out there and to see how the market responds to them.
Thank you, gentlemen. That's all, Madam Chair.
All right, thank you. Commissioner Whitfield.
Thank you, Madam Chairman. Good morning. Good to have both of you this morning with us.
Good morning.
Got a few questions for you. I guess you, Mr. Raftery. First question deals with the concentration of DER resources maybe in a certain area. And given that, do you anticipate placing any limitations on distributed energy resource installations due to concentration on specific circuits? And if so, would customers impacted by these limitations have any alternative to access DER resources other than subscribing to shared solar?
There are considerations in the current interconnection standards, the state standards of up to 20 kW for residential and 100 kW for non-residential, as there are in the FERC small generator interconnection process, as well as the large generator interconnection process. As you know, the Act also sets out for the utilities and the ORS and interested parties to promulgate new standards. And we have begun the evaluation of new interconnection standards and have absolutely taken that into consideration. Namely, we want to ensure that some of the smaller systems have the ability on a circuit to interconnect without having a number of large installations gobble up all of the capacity. So there will be an interconnection standard proposed to this commission for approval, which I think absolutely takes into consideration potentially your concern about ensuring that there's reserved capacity for the smaller individuals on the different circuits, and we think we're modeling something that will meet that need.
Well, I saw that in the Act about the interconnection standard, and I was just wondering, I guess you're going to be developing those standards as this program unfolds, and so that hopefully you don't get ahead with a specific concentration in one area on a specific circuit.
Yes, it has not been an issue to date, and we intend on petitioning those new interconnection standards very shortly, absolutely this year.
Well, thank you, Mr. Raftery. Also, a couple of more questions for you. I'm going to lay low on you for right now, Mr. Rooks, but On page 2 of your supplemental direct testimony, you outline, I'll give you a second to get there, I'm sorry.
I think I'm there.
You there?
Yes.
You outline how much a customer should expect to pay for a 100-watt solar panel in SCE&G's community solar program. What's the energy usage of a typical residential customer and a typical commercial customer in terms of use? I guess what I'm getting at is how many panels would a customer need?
Okay. We typically, when we talk about bills, with a residential customer bill, we talk about 1,000 kilowatt hours per month. So that would be about 12,000 kilowatt hours per year. A kilowatt of solar, whether it's on the roof or on the ground, or in a community solar farm, produces about 1,400 kilowatt hours a year. So it obviously is very specific to the residents and how they are consuming energy over the year, but 1 kilowatt puts out about 1,400 kilowatt hours. I should have brought my calculator. A 12,000 kilowatt hour residence divided by 1,400 is about 8. It's about 8. So you're looking at about 8 kilowatt hours. However, the standard installation is more about 4 on a rooftop. So if a residential customer wanted to fully offset their residential energy load or energy requirements, they're looking at about 8 kilowatts worth of purchases in the community solar farm. With each panel being 100 watts, that's it's about 80, right? It's about 80 panels that we'll be buying. Is anyone going to check my math on that?
Subject to review.
Yeah, subject to review.
Well, realizing you don't have a calculator with you, I don't guess you could do that well in your head with a commercial customer numbers, could you?
Yeah, I know I couldn't. And that's just because the commercial customers, the range of their usage, yeah, it just varies so much. They're typically looking at, and I'm talking about maybe small commercial, they're looking at a kilowatt purchase of maybe 20 to 40 kilowatts, and it certainly can go up into the hundreds of kilowatt, but it really depends on what kind of business they have.
Next, I guess this is kind of for either one of you, so I'll give you a shot here, Mr. Rooks, but either one of you really could answer this one. Could either one of you address some concerns, public concerns that there might be with subsidizing cost of solar panels for customers, from the other customers, for the customers who take advantage of solar opportunities? Could either one of you want to tackle that one?
I'd be happy to. Your consumer protection is an important thing, whether it be the leasing provisions in the Act, or whether it's the cost recovery caps that Alan talked about, $1 per month for residential customer and the different items. Yeah, I think that as we evaluate our programs and as we work on customer education, it's incredibly important. We have done over, my goodness, 20 different presentations to 700 different leaders and influencers throughout the community, including building associations, nonprofit organizations, the Association of South Carolina Energy Managers, the Solar Business Alliance, the South Carolina Solar Council. We're really trying to educate consumers. We've done a number of Voice of the Customers with a panel of over 3,000 customers and asked them, what do you know about solar? What interests you? Where would you go for information? And over 90% of them say their first place that they're going to come for information is to the utility. They're coming to SCE&G. And 2/3 of those customers have said, I want to go to your website to get information. And we feel we have a strong website that explains the current programs clearly. We will update that with the approved programs when they are approved. We've also recently updated our website with a homeowner's guide. In conjunction with the South Carolina Energy Office, we developed a homeowner's guide which talks about the costs and benefits of solar ownership, and it specifically lists a number of different questions that that our customers should be asking the installers, that should be asking the leasing companies, questions that they should ask their insurance agent about their home, ensuring that they have the proper coverage. So customer education is an important point. Consumer protections, we have some in place. That is not to say that there will not be bad actors out there and attempting to take advantage of our customers, but I think we've done everything we can to educate and be there to support our customers.
To tag along with Mr. Raftery's response, I do feel like the legislature contemplated that we were entering into a period here of research and development activity, if you will. And I think those caps were a key consumer protection there to make sure that things didn't go, the spending didn't go unchecked or anything along those lines. So I think those caps provide a reasonable degree of certainty for customers that these costs are not going to spiral up.
Thank you both for your answers to that one. Lastly, I got one more question. This is probably to you again, Mr. Raftery. The company's proposing to build utility-scale solar facilities in its territory. I saw that in your testimony, and I've also heard you say it again here on the stand today. I think you mentioned one in the Casey, South Carolina area, and one in North Charleston. And I know that was you got in motion with those, so to speak, pre-settlement agreement, but now per the settlement agreement, I think you've opened it up to some non-owned territory by the company, in the company's service territory, but on properties potentially not owned by the company. How will this commission be informed as to where those facilities will be located, how much they will cost to be built and operated, and any problems associated potentially with siting of these facilities?
It's a great point in regards to the first two utility-scale solar farms that we're building are on company-owned property at Otari off I-77 and off of Leeds Avenue in North Charleston. The company's intent was always to additionally issue RFPs for the best solar developer to bring to us their project, and it will go through a transparent RFP process as you would expect, therefore ensuring we get the appropriate market prices. The Act certainly has a spirit of education and promotion of solar. Therefore, one of the items that we'll take into consideration in going through the RFP bids will be ensuring that it's spread throughout the territory and not just one location. We would like it to be as visible as possible so that people know that South Carolina does have solar capabilities. In regards to noticing the commission of the RFP results, I'm unclear as to the answer to that, and I don't know procedurally how that happes.
Would you report back to ORS or something? Or
yeah, I certainly see that happening. Yes,
and certainly these costs will be brought up for review in the annual fuel proceeding each year. So
thank you.
So yeah, and they'll pass through ORS audit review at that point in time.
Thank you both. That's all I have, Madam Chairman, at this time.
All right, thank you. Commissioner Randall.
Thank you, Madam Chair. Thank you, gentlemen, for being here today. I was just real impressed that you and I were coming up with the same numbers in our head while we were doing that.
Okay, good. Does that mean we're both
Please
wrong?
Don't believe that. Do not believe that.
Just thought I'd throw that out. And I appreciate somebody listening to the question about the pollen problem on panels. I think that's a glad people are paying attention here.
Yeah.
Couple of questions. First, Mr. Raftery, on page 12 of your direct testimony, you're talking about the use of 2 meters, for solar installations.
Yes.
And you explained it in your testimony, but talk to us a little bit about how that works.
Absolutely. So the as stipulated in the net energy metering settlement agreement, it talks about the recovery mechanism for net energy metering customers and the need for the utility to set metering standards to measure the full output. That is louder. The output of the solar PV system. So SC&G will enlist the same bidirectional meters, those that we use today for net energy metering customers, but we'll place it specifically on the solar PV installation. So the customer will have their standard house meter and then the second bidirectional meter, which will measure both ways, time of use, and it will also measure demand. And you might ask, why would the company be interested in power going to the solar panel? Well, we don't know what's connected behind that meter, so it will be interesting data to see if that actually occurs.
Thank you. Will the cost of having the extra meter or those metering costs, are they going to be recovered through your normal metering account, or is that something that's set up in the distributed energy resource plan?
The second meter would be part of the distributed energy resource incremental costs.
Okay, thank you. With the whole distributed energy program, is this going to require additional people to be hired by SC&G?
We've identified the need to hire 2 additional people. A senior engineer to help us with those utility scale solar farms. There's a lot to manage there, as well as a program manager just to help the internal coordination amongst all of the different departments, whether it be customer service, marketing, IT, rates and regulatory, a whole host of different organizations. The company will, to the best of their ability, lean on other internal departments like electric operations and those I just mentioned to see if we can't support these programs with kind of time sharing of other resources. If we find that that proves to be a challenge, we have lined up the necessary contracts in place to help us with things like field inspections, to do interconnection inspections. So we'll have some contractors help us. And if at any time we recognize there's a sustained need for employees, we'll need to go out there, articulate the need, and hire them. But at this moment, our approach is 2 additional hires, leaning on other departments, falling back to contractors, and then any potential hires after that.
Okay, thank you. Mr. Rooks.
Yes, sir.
You talked about Section 5827-865A, and in your testimony, then you went through it pretty fast right then. So I wanted to make sure that I'm on the same page with you. All right. It says that distributed energy resource costs be allocated and recovered from customers based on the same method that's used by the utility to allocate and recover variable environmental cost. And I know when I'm thinking on carry forward cost, with your regular environmental costs you carry forward by customer class. And you were talking about the protection, making sure it's level by customer class. Will you carry forward distributed energy costs by customer class as well, like you do with the environmental?
I think the plan is to take that under recovery each year and add that.
Mr. Rooks, you got to speak in that microphone, please. I'm sorry, the people in the cheap seats can't hear you.
I think the plan is to take those costs each year, that under recovered balance, add that back in with the costs that were prudently incurred for that given year, and allocate it amongst the customer classes.
Okay, so
that's currently the intent, and with the primary difference between this cost recovery mechanism and variable environmental, that we have those caps in place.
Mm-hmm.
So that's an additional layer that we don't have or don't see with those variable environmental costs, if you will.
I got you. Thank you. I appreciate it.
Thank you. Commissioner Elam.
Good morning, gentlemen.
Good morning.
Morning.
Mr. Raftery, do you have a copy of the company's original petition
I do.
If you could turn to page 12 and paragraph 48. If you could walk us through the process for calculating a customer's credit for participating in the shared solar facility as described in that paragraph?
Sure, I'd be happy to. So a community solar farm will be approximately 1 megawatt to 5 megawatts. I mean, it can vary, but a customer will purchase panels. They'll purchase the number of panels that is of interest to them. The percentage of the capacity that those panels represent over the total farm will be multiplied by the farm's total monthly output in kilowatt hours. So if you were a customer that bought 1% of the panels in a community solar farm, you would receive monthly 1% of the output from the community solar farm. You would receive that on your SC bill at a credit rate of 10 cents. So the kilowatt hours, your pro rata share of the farm times 10 cents. You would receive that every month.
At what point does a third-party developer become involved with potential customers?
They,
Mr. Rafferty, I'm sorry.
Again?
Yeah.
I thought,
Just pull it
I thought I
really
was
close.
eating it already.
Please, yeah.
I'm going to hold it, sorry. I'm sorry. Commissioner Elam, could you repeat the question?
At what point would a third-party solar developer enter that process with a customer buying?
The partnership with the third-party community solar developer will be at the beginning. It'll be a partnership with SC&G to issue RFPs and to find the best locations for community solar farms. The community solar project developer will market with us. They will market to our customers. They will market to the residential customers and those tax exempts, and talk about the benefits of community solar. They will talk about the information that we just talked about what does it cost to buy a panel, what would be the bill credit for the appropriate panels. The community solar project developer would also be responsible for signing the contracts. They might finance the panels with the customer, and they would essentially produce a closing document for the customer to sign. The relationship then is primarily between the community solar project developer and SC&G, getting the data, the kilowatt hour, the monthly data, the pro-rata share, and getting it on the customer's bill. At any time, if the customer wants to sell their panels, they want to gift their panels, that's a conversation that they would have with the community solar project developer, and those panels would then be reassigned to another SC&G customer.
Okay. Is there any, or will there be any limitation on the amount of panels a customer can buy in a community solar farm?
There are. No more than offsetting 100% of their own residence's energy requirements.
And how is that determined?
Primarily by the metering we have in place. So we will look at the annual consumption for those customers at their premise. If it's a new customer, we'll need to estimate it, similar to what we do for budget billing.
Will a customer have any recourse if he or she disagrees with the limitation? Maybe they're anticipating using more power at home for some reason. Will that be a process they can ask to, in essence, get more solar panel capacity than their historical bill shows?
We'll work our way through that. Yeah,
Okay.
When that comes up, the company, as we do with all the other payment arrangements and other interactions with their customers, we'll work our way through it. But the guideline is 100% partial or 100% of their own energy offset.
Now, with the community solar program, will the subscribers have to live within a particular community's limits in order to participate in the program, or will subscribers be eligible if they live outside that particular community's limits?
They need to be an SC&G customer, and that's the only limit.
Okay. So if I'm a customer here in Columbia, I could participate in one in Aiken?
That's absolutely correct.
And this may be for either one of you, turn to the settlement agreement for me. And again, this is community solar. I'm talking about paragraph B14 on page 8 of 24.
I'm there.
Okay, can you explain the thinking behind this settlement provision that the community solar is not going to count toward the small scale requirement?
There are arguments to be made that a residential customer buying and owning panels of a capacity less than 20 kW could account for the small carve out of the 25%. As listed in the Act. And there are arguments that say that no, it's a utility scale solar farm. In the spirit of moving forward, the settling parties agreed not to count it at this time,
Okay.
but to have the ability down the road to have that conversation if necessary. So that's the spirit behind paragraph B14.
Okay. Staying on the community solar, who will retain the renewable energy credits?
For all of the DER programs, the company will retain the renewable energy credits.
Okay. You turn page, still on the settlement, page 11, paragraph B26. If you could talk about those particular expenses that this paragraph agrees to classify as avoided costs. Are the costs, could they be considered incremental costs?
Which costs are we referring to?
We're talking about B26?
Mm-hmm.
Okay, the first one, I guess, is the amounts paid under avoided cost rates. Mm-hmm. That's a normally bought under purpose, normally an avoided cost. So I'm trying to understand why that is particularly in the settlement agreement.
We would essentially use avoided cost. I believe the statute refers to the lower of negotiated rates.
Okay.
Or the company's most recently approved PURPA rate.
Okay.
And so what would happen is the company would flow through its most recently approved avoided cost rate through the avoided cost piece, which is not subject to the caps. And then any amount over that I would view as flowing through the incremental cost side, subject to the caps.
Okay. Number 2 in that paragraph says amounts paid for generation purchased at the company's avoided cost rates from community solar net metering and BCA. Are those costs, would they otherwise be treated as incremental but for this agreement?
No, I don't think so.
Okay. And again, I'm just asking why is that in the settlement agreement?
Similar to other items, I think it was just to be explicitly clear.
Yeah, they still can't hear in the back. I'm sorry, gentlemen, but just, yeah, put it in your mouth, I guess.
Trade.
My apologies. Can you hear me now?
That's better. That's
Okay.
better.
No?
They still are a little shaky. Better?
I can yell, but I don't.
Okay.
We're just trying to make you as uncomfortable as possible.
Sounds loud to us.
All right.
We'll give that a try.
I think, can you hear me?
Okay,
Okay,
thank you.
welcome.
Actually, you may not be it right now. Mr. Rooks, if you could turn to your supplemental testimony, and I believe you've already discussed your supplemental exhibit AWR 1.
Okay, I'm there.
Now, the estimated charge to industrial customers is shown to be at the statutory annual cap for each year, correct?
That's correct.
And that's at line 10?
Correct. Correct.
Does this mean that residential and commercial customers will be subsidizing the industrial customers for the life of the program?
It simply means that no customer class is going to exceed its reasonable threshold as mandated by the caps.
Okay.
This was the, as John has pointed out in the course of the settlement negotiations, this was the best path forward to ensure that we would comply with the law and at the same time be able to achieve the goals mandated by the legislature.
Okay, let me see if I understand. Well, actually, what's your projection of what the first year bill line item for a residential customer will be? I see you've got an estimated annual of $1.74.
That's correct.
All right, so.
That amount divided by 12.
Yeah, I was also told there would be no math, so sometimes I don't try. And if you over or under recover that first year, that will be taken care of in the next year.
It will be put into one bucket of unrecovered costs.
Right.
For allocation.
If you don't recover all of the incremental costs in year one, is the amount that is unrecovered going to go into the calculation of the incremental cost for year two, or is it going to go into the avoided cost barrel and be allocated among all customer classes?
No, incremental costs will stay incremental costs and with that family of cost, if you will. So
Okay.
it will be, you're correct, it will be applied in year two or the following year.
All right. Will the costs for each customer class, in essence, support themselves, or is the incremental cost for year two just the sum of all the unrecovered incremental costs from the year before, or is it segregated by customer class?
We would view that as one balance with the way we're proposing to do it here.
Okay. Thank you. I have nothing further.
Okay, thank you, Commissioner Elam. Commissioner Fleming.
Good morning.
Good morning.
Mr. Rafferty, you've already talked somewhat about the customer outreach and education programs that are planned. I wonder if you could go into a little bit more detail about what's happening once this program moves forward. Will there be additional outreach?
There will be. I recall in the prior hearing there was conversations about the bill and what will it say and will there be messages on the bill and inserts and that sort of conversation. There will be the traditional messaging that way, but what we're focused on now is our customer service training department making sure that they understand the programs inside and out, and training those customer service representatives so that they can speak competently and clearly with the customers when they call us. I mentioned the website and the customer's preference to come to us for information, and the development on keeping the website updated. The Home Energy Guide is a wonderful guide. I mean, it's something that really is going to help customers understand the costs and benefits of solar, and as I mentioned, the different questions that they should ask the people that they're engaging in business. We'll continue to make road shows. I mentioned the 700 different people that we have spoken with and explaining the programs. We will continue to do that. I also envision us using the advisory group, the DER advisory group, and soliciting ideas on how to ensure the consumers, number one, understand the programs that are available to them, but also ensure that they are protected from, as I mentioned earlier, any bad actors. So a number of activities already underway, completed. We'll continue those. And as well as the development of a marketing plan, any sort of additional marketing outside of the ordinary that we would do. So there's a group exploring options of how to be even more proactive in communicating these programs.
Okay. And you mentioned the advisory group. I know in the settlement it said that interveners could certainly be a part of that group. And it is limited. Will there be consumers as well, customers? Representation?
The consumer representation, in my mind, it's not specifically listed, but I absolutely think the Office of Regulatory staff and their members will be there ensuring the consumers are represented, but there aren't any specific consumer advocacy groups per se contemplated on that group right now.
Okay. And do you have any plans in place if there are like any breaches of data and information, or it seems the challenges that come with this as well as the benefits?
So the SC&G or SCANA has a number of different incident response plans. One is our data breach incident response plan that's been in place for as long as I've been with the company. It includes a process of bringing together parties to assess the data breach and to inform necessary agencies as well as the customer. We also have a cybersecurity incident response plan, which also is focused more on bad actors kind of hacking into our different systems. And it too has a set of different levels, a set of different individuals to be included and communicated with, both internally and externally. And if customers are impacted, they are one of those parties as well.
And if I recall correctly, when we were doing the initial hearing, the 2014 docket on this, one of the SCE&G people, I thought, said they were really aggressively going after new housing with solar. Is that, does that continue to be part of the plan?
I don't recall who said it or exactly what they said. I wasn't here, but I can tell you as part of those 700 different individuals that I'm meeting with and sharing the programs with, it includes the High Performance Building Council. It includes builders themselves, so people that are building new homes that see solar as an ability to market in addition to high performing energy efficiency homes. So I think that it's a market segment that can benefit from this. Certainly if you're building a new home and you're constructing the roof to support solar, it's a heck of a lot better than doing it 10 or 15 years later and then reassessing things. So I think it'll be an important part of the adoptions, and we're trying to get out there and communicate it so that they can be successful.
Okay. Would it increase the cost of the housing?
I think that's the opportune time to do it. certainly they don't come free. You know, there will be the installation and the cost of materials, but it's the opportune time to do it. I mean, you're constructing from the ground up. You take it into consideration and place the panels there. I mean, and take into consideration the proper roof angle, pitches, and orientation to the sun. I mean, it is an ideal time to consider installing solar.
And did I understand you to say that the RECs, even after the 10-year period, would stay with the company?
The RECs stay with the company, and any value derived from those are applied back to the DER incremental account. They remain with the company until all of the DER incremental costs are recovered and the charge is removed from the customer's bill. At that time, the settlement agreement states that the RECs would be owned by the customers that have the solar PV.
Okay. And you will keep monthly updates on your website of the energy?
Yeah, correct. Another part talks about production-based incentives and giving transparency to not only the customers about what production-based incentives are available at what tier, but also the installers, that they know how they can market the net energy metering plus a production-based incentive.
And could you walk me through the process that SCE&G will do as far as having solar panels installed under your program?
From a customer's perspective, so a residential or commercial, sure. Well, a residential or commercial customer would find some interest in solar. They would go to our website and learn more. They would call our call center. They might get directed to our specialty team if they have specific questions. And they might come across something like Solarize SC, where, you know, throughout the service territory, a group of installers are going and marketing, you know, solar. Once there's been an interest and the individual will either be moving forward in a leasing agreement or ownership on rooftop, the customer or the installer or the leasing company would come to our website and begin the interconnection application process. For residential customers, that brings a $100 interconnection application fee to cover the administrative costs for those. They would list their account, whether or not they are interested in in the net metering plus a production-based incentive, or if it's a commercial customer, they would list the size of their system, if it's less than 20 kW or 20 to 100 kW or 100 to 1 megawatt. The company would get that application online, and we would assess the circuit information. We would ensure that it is safe for that circuit to assume that additional generation. Within a matter of days, we would approve that interconnection application. They would have, as well as commit under the production-based incentive, to a certain PBI. So we would say, you know, starting out, it would be 4 cents. Your application has been approved. You will get 4 cents. You will have 180 days to build your system, and then apply for interconnection. And the company, there will be local code officials that will do the inspection as they normally would for any electrical there. The company will send a field representative once the system is ready for that second meter to be set. We'll inspect everything on their system, meets their application, will ensure that the inverters have the right UL safety codes on them and that it matches what their application has. And provided that inspection is successful, we will approve it and we will set that meter, and they will begin the process of receiving a production-based incentive on their bill for 10 years. So it's how they get interested on the front end depends, but they would engage us through the website for the interconnection application and approval, locking in a production-based incentive, and then it's really followed up with the field inspection and then getting the billing set up.
And you would use only installers that are certified by ORS, correct?
Well, the,
That was,
yeah, we wouldn't, obviously, the company doesn't use the installers, the customers would. The customers that elect to lease their system will need to lease from a company that is certified by the Office of Regulatory Staff. The Office of Regulatory Staff does not certify an installer who is going to just simply install solar panels and the customer is going to own them. You got customer ownership, bunch of installers, that's not contemplated under the Act to be certified under the Office of Regulatory Staff. Leasing is.
okay. I thought they were going to certify all of the installers, but it's just the people they're leasing
Just the
from.
leasing companies.
Okay. And on the bill credit agreement, I know that that's no longer for residential,
Correct.
but it is in place for commercial and
Correct.
industrial.
Correct.
Are there any, I know the concern for residential was about the tax consequence. Is that not an issue for commercial and industrial?
Yes, so tax implications, the first thing that anyone will say in any meeting is, I'm not a tax attorney. I mean, everyone says that I'm not a tax attorney, but they will bring tax implications. For a commercial customer, they are more familiar and more comfortable in understanding what might their tax implications be. So there might be tax implications for a bill credit agreement where they're selling all the power to the utility, but they have been in that income stream sort of process in other areas, and they feel comfortable managing it. That's why we kept the bill credit agreements for those commercial customers.
Okay. And just for clarification, in the settlement agreement on page 11, and they say it's for in the future, number 1, it says the avoided cost component of SCE&G owned generation constructed to implement a DERF for cost recovery. Could you explain that?
Commissioner, can you point me to the which one are you looking at here? Paragraph?
Okay, it's paragraph 26, B26.
Okay.
And it's the second set of numbers, and it's number 1.
Okay. Yeah, those would be the avoided cost rates as last approved by the commission, would be considered avoided costs.
Even though it's being constructed by SCE&G.
That's correct.
Because I think earlier you had said it would be, I wrote it down, another entity for avoided costs, but it counts even though it's your.
Yeah, it would be a distributed energy resource program avoided cost. To be counted.
The facility.
Essentially, all of these costs, if you will, are going to be allocated off demand ratios. It's just that the avoided cost determination is used to say which costs go down this path that's not subject to the caps and will be applied through a per kilowatt hour charge, and then which costs will flow down the incremental cost path subject to the caps and to be applied on a per account basis. But those avoided costs, if you will, are put there because of our obligation to provide least cost power to our customers.
Okay.
And so I think that was, an important part of PURPA, that the company not be required to purchase power that would not be deemed economical. And so that was, I think, kind of around the genesis of the whole avoided cost and originating with PURPA.
Okay. So like your solar farms would be, that would be the way they'd be accounted for then?
The avoided cost would flow through to that bucket, and any amounts in excess of that would go to the incremental cost bucket.
Okay. Thank you.
All right. Commissioners, any other questions? Okay. I just have I'm sorry, Commissioner Howard.
I'm late. 2 quick questions. Mr. Rafferty, do you think or Ms. Rook, is DER program dispatchable at any point in time?
No, they're not dispatchable, but with that second metering, we can better model them and understand the impact they will have on our distribution and transmission system.
Do you think they could compromise economic dispatcher times?
Yeah, I don't believe that will be the case. It will offset some power, and as we have an economic dispatch, it will offset power at that marginal cost, if you will. So I don't believe these resources will have an impact on our economic dispatch.
Next question, last question, I'll give her a fair warning, but I'll also ask Mrs. Schaefer this question also. Does the installation of rooftop solar panels on a house increase or decrease the value of that home?
It's a great question, and there are two different thoughts. I mean, there are conflicting studies, and it's inconclusive. I think you can find a study that say it'll increase the cost, and you can find a study that says it does not increase the cost. So I don't think there's one authority that can give that answer. It just depends, unfortunately.
I didn't know if any real estate board or commission or anything has done that study on that. I was just curious. Thank you very much. Thank you, Madam Chairman.
Okay, thank you, gentlemen. Now, if Commissioner Howard is finished, okay. All right, then I just have a few. He asked about the panels, whether they devalue or add value to the housing costs. How about insurance costs? Are y'all aware of that? We asked the Duke companies, and we would like to ask you as well.
As I mentioned in the homeowners guide, it directs customers to talk with their insurance agent. I'm not aware of it being denied, the homeowner's insurance being canceled as a result of solar installation, nor am I aware of premiums increasing. It's a personal situation that they need to have the conversation with their insurance agent to understand what their situation is.
Okay. Now let me ask you this: how much participation do you anticipate initially in that? Is it 4 cent group?
Yeah. So the 4 cent tier is from 0 to 2.5 megawatts.
So that's the initial.
Yeah. So with the typical residential rooftop installation of being about 4 kilowatts, that would be about 800 customers in
Okay.
that first segment.
And do you expect that to happen pretty quickly, or?
Yeah, I think that the remainder of this year, as soon as these programs get approved, and next year, there will be a rush. I mean, there will be individuals interested in taking advantage of the investment tax credits, the federal ones, which are set to expire for residential and set to go from 30% to 20% for business. I think there will be a rush, and the model forecast contemplates that kind of a hump, but it also provides a glide path down through the end of the Act's stipulated period of being through December 31st of 2020.
Okay. As far as the community solar, will the customer only deal with the company, or how exactly does that work in terms of, any kind of customer service questions they might have? Would that all be directed to the company, or?
It depends on the question. We'll certainly field any questions and mediate any issues. I mean, we pride ourselves in customer service and have a department that's fully focused on that and takes it to heart. There will be defined channels, though, where the customer can interact with the solar farm developer, the community solar farm developer, for things like reassignment of panels. I mean, that will be a transaction that's conducted through them. But if any of our community solar customers has a question, we will answer it or route it to the right person.
Okay. All right, thank you. And then finally, I know someone asked about the cross-subsidization, and maybe I missed it. Will you just tell me your position on that?
The cross-subsidization from solar, people that are benefiting from solar?
Yeah, to non-users, specifically, low income.
Well, so the one item in the settlement agreement talks about focusing the first two advisory groups sessions on developing an economically challenged program and examining that. We feel the community solar is an opportunity or an offering for that segment, but there might be something that we might need to change and change the financials.
I'm sorry, because did you say that it is available to the credit challenged, or?
It's open to any residential customer.
Okay.
Yeah.
But without regard for credit risk?
Well, it depends on their ability to buy the panels. If they need to finance it, there will be certain financing terms.
Okay.
So yeah, that is outright purchasing or financing them. Regarding cross-subsidization and the conversation about it occurring, if a customer were to ask us, am I paying for my neighbor's solar, then I'd say, number one, I can't talk to you about your neighbor's account, but I would go back to the intent of the law. I talk about the intent of bringing good renewable resources to South Carolina. Good jobs will be coming to produce, to support it. I'd also make sure that they understand that they have the ability to participate as an electric customer under these DER programs. But I wouldn't go there before I talk about energy efficiency.
Okay.
I want to make sure that they understand about the energy efficiency programs and that how it very well might be a better dollar spent for efficiency before you install solar.
Okay. All right, excellent. Thank you. I think those are all the questions I have. Mr. Burgess, you have any redirect?
No redirect, Madam Chairman, and this concludes the company's case.
Okay. All right, Mr. Raftery, Mr. Rooks, you may step down. Let's go ahead and break for lunch now. We'll go come back at 1:25.